SJC-13845, Helen Banevicius et al. Versus Town of Barnstable et al.
I just want to note that Justice Kapker is recused from this final case. And Mr. Sabat.
Thank you, Your Honor. Morning, members of the court. May it please the court. This is a case that presents unique elements never before presented with respect to Massachusetts General Laws, Chapter 61A. On the one hand, while Chapter 61A, Section 14, mandates strict compliance with its notice requirements that would trigger a right of first refusal in favor of the town of Barnstable, here, those notice requirements were never met. Except for one of the 6 parties who was entitled to notice, namely the town manager, none of the others received any notice. The town of Barnstable itself has admitted that the landowner here did not give notice to any of those parties.
Can we start with that first issue? Because you said a lot of it is something that's brand new, but some of it is really old, and that's standing. So where does the text of Chapter 61A, where does the legislature assign the intent for enforcement of that to an abutter?
The statute does not specify that. It does not specify that abutters have a right to enforce the statute.
Isn't that a problem for you?
No, I would submit no, and I would submit that for a number of reasons. As we have argued in the brief, the United States Supreme Court has recognized that aesthetic interests are interests that are cognizable and can establish a cognizable injury. The objective of this statute, in fact, the objective of the entire scheme of Chapter 61, is to preserve open space. And I would submit that that is implicit in the right of the town of Barnstable, any town, to exercise a right of first refusal. And what would that purpose be? Is it that the town of Barnstable is going to buy this to operate a cranberry bog? Probably not. The whole reason for that would be so that the town can preserve this land for open space.
You're asking us to import zoning law principles into this statute.
Not really. I would submit that the zoning statutes offer a guide and tell us that the legislature has placed significant value on the status of an abutter in terms of having a land interest or having an interest in the process, having an interest in the development of the adjoining or abutting parcel.
And is that expressly stated in the zoning statutes?
I'm sorry, Your Honor?
Is that legislatively assigned significance to abutters? Is that in the zoning statutes expressly?
It is, because the zoning statute...
So I guess I'm wondering why, if the legislature had thought the same significance should attach to abutters vis-a-vis 61A, the legislature would not have put that in there.
Well, I would submit that the thrust of the statute, when drafted, was to allow for towns to preserve open space. And I would submit that given the legislative history, given the overall overriding objective to preserve open space, that it wasn't that abutters were specifically excluded, but they were not referenced, they were not explicated in the statute. The case law subsequently has made it clear that if there is a cognizable injury, that could endow a taxpayer, for example, a citizen, with standing. In those cases, for example, in the Riley case, which is an appeals court case, Riley versus Hopedale, the court began to examine that question, whether or not there was a cognizable injury on the part of those objectors, those plaintiffs, and determined that there was not, because none of them were abutters, none of them adjoined the property. There's another element.
Is that the reason why Riley stated that those citizens did not have standing?
That is what I would submit. In that same paragraph, they do make the statement that only landowners whose property can avail itself of 61, the forestry section of this statute, have rights under the statute. But at the beginning of that same paragraph, and that's what the appellees rely on, but at the beginning of that paragraph, you will note that the court does examine whether or not there's a cognizable injury. There's something else at play here, too, aside from merely being abutters. That is something that we did not emphasize in the brief, but I would like to underscore here. 3 of these plaintiffs who have submitted affidavits are servient estates to this cranberry bog. In other words, the cranberry bog has easements over their land. That easement has 2 parts. First part is that the owner of the cranberry bog has a right to cross vehicle tracks that cross the property of the 3 abutters. They are Ronald Knight and his wife, the Wards, and Linda Powers. They each have easements that run across their land. And the second part is that there is a further right to use other areas of their property, north and northwest of the vehicle tracks, so in furtherance of the operation of the cranberry bog. There's also a right to bring in utilities over the vehicle tracks. That's in the first part of that easement. If this property is sold, this cranberry bog is sold, those easement rights are part of the bundle of rights that would be conveyed and would accrue to any purchaser, including the town of Barnstable, if it exercised its right of first refusal.
Can I just ask about, just going back to standing for a second, even if we said that your clients had an interest in what happens here, what's the argument that there's an actual injury if the town gets to decide? It's up to the town whether it purchases the land. So the plaintiffs don't have any say in that.
There is no question about that, and we agree with that completely. That is completely discretionary with the town of Barnstable as to whether or not it wants to exercise this right of first refusal or not. What we contest is that the process was not followed. That process would have required notice to the Conservation Commission, Planning Board, Board of Assessors, all boards appointed by the town council and the town council itself.
Let's imagine that they go back and do it correctly.
Yes.
The town still has the discretion to decide whether it's going to purchase it or not.
That is correct, Your Honor. They do.
Okay.
But what we are saying is that give us a chance. Give the notice to the proper parties here. There is in the appendix a reference to the Conservation Commission in an executive session that indicated to town council, SEL, that they wanted to be notified about the 61A process. The Conservation Commission might have lobbied the town council, CIL, to in fact exercise the right of first refusal. If this had become a matter of true public notice, the town council would have taken this up in an open public session.
Council, isn't that where we actually are? Because town council eventually did write and say your notice was insufficient because you didn't send it to all the right people. And so the town has actually already done the thing that you're arguing was mandatory for it to do, albeit belatedly. And so theoretically, couldn't the town, the town is sort of, there's still the possibility of a right of first refusal, correct?
Well, there is if the town will act to enforce its rights, which is what our mandamus count is about.
Well, but how can you compel them using mandamus to decide to take the land if it's a discretionary decision, as you agree?
Right.
What we're trying to compel them to do is to bring an action in the Superior Court to have a declaration that the conveyance into Bog Partners LLC was invalid, and that in fact the right of first refusal endures.
And so you can't. There's no mandamus will not lie unless there's an absolute requirement on the official or entity to do something, correct?
Well, if they do nothing, if they just write this letter and then do nothing after that, it's utterly ineffective. They are not, in fact, enforcing their right of first refusal.
But
It's
isn't it
discretionary.
discretionary as to whether to waive their right to enforce it?
I'm not sure that they can. That the town can. That was the issue in the Riley case. In fact, is whether or not the town had the authority to waive, as part of a settlement, its right of first refusal. The town has not made a decision officially to waive its right of first refusal in this. There's some reference in the record that the town avers that in an executive session it was decided not to litigate the question. But the town,
Isn't that the town's choice?
I'm sorry, Your Honor?
Isn't that the town's choice to decide?
It is the town's choice to determine whether or not they wish to litigate the question. That is true.
But you just said that the mandamus, the writ of mandamus that you're seeking is to compel the town to litigate the issue.
Well, it's to compel the town to litigate the issue to try to enforce its rights. The plaintiffs cannot do that for the town. Only the town can do that. And if we prevail on the declaration, the declaratory judgment count, which is the count, both of those counts we aver that we have standing on, if we can get to court on that, if we can have a hearing on that, then there will be a declaration that will undermine this title, which in fact is deficient because the notice requirements were not complied with. If there's a declaration to that effect, then this process will have to start all over again.
Well, can I go back to that standing part about the plaintiffs seeking to enforce the town's rights here? I just want to make sure I understand what you said earlier. Is it just the conduit by which you say the abutters get to do this, the aesthetic and environmental concerns?
That's the nature of their injury, because that would affect the value. It's more than just a conduit. That would affect, what I'm saying is that.
Well, I'm trying to see how you're importing the zoning considerations into 61A. Is that how the mechanism by which you're doing that?
Yes, through the declaratory judgment statute, we are saying that that the plaintiffs have standing because they have interests that have a value.
That's what I'm getting at. What are those specific interests? Are they just those two?
If they, as they've testified in their affidavits, they have the vista, they have the tranquility, they have the aesthetics of being able to overlook a cranberry bog, an active working cranberry bog. That adds value to their properties. They have all testified that they selected those properties and bought them because of that element, because of that ambience. And
I get you. That's you're leading to my point. So if what's the limiting principle then on the ability of 61A conveyances if somebody just gets to say, you're messing up with my vista, where that's a zoning consideration. These are all kind of zoning implications that you're now embedding into 61A that don't appear there by text. So why should we do that?
That only would apply in a case like this, where the process has been abrogated. That would not apply generally. For example, if the town didn't exercise its right of first refusal, I would submit and agree that an abutter, just because of his extent interest, does not have a right to overturn that or challenge that. That is, as I've said, completely discretionary. But where we have a situation here where the process was completely corrupted, and I mean in the sense that it wasn't adhered to, then in that case, an abutter with this cognizable injury should be able to say this was not the right process, this deserves a public hearing, all of these parties deserve to be noticed, and that should be declared by the Superior Court. And as a result, that would cause this entire process to have to start all over
What's
again.
your best case for that proposition? Your best case for that proposition?
My best case for that proposition is based on the affidavits, the testimony of the plaintiffs.
No, your best case. Court case.
Oh, the best case. I see. The best court case. I would say the best court case for that is Scott versus the town of Sudbury, where Scott laid out the legislative history, which indicated clearly that these notice requirements could not be waived. And I would also say that given my interpretation of the Riley decision, the appeals court decision, that if you look at that paragraph very closely, they do assess, they do analyze whether there is a cognizable injury. And I would also go to Enos, which is the 2000 Supreme Judicial Court case, which established a framework for analyzing injury. One of those elements was whether or not allowing standing would have an adverse effect. Here it would not. It would initiate the process that should have been undertaken originally. And the final element of that framework is whether or not there are other avenues available to the plaintiff. And here there are none. There is really only one, and that is the declaratory judgment statute. And I would also aver a second one, which is the mandamus, to compel the town to take an active stand to enforce its right of first refusal. And so for those reasons, I submit that the Superior Court was wrong in its determination. He jumped to the conclusion that he went right to the discretionary part of this, and we, of course, have challenged the fact that the town manager did not have the authority to waive or to exercise the right of first refusal. That was totally within the town council, not within the town manager. Thank you very much.
Thank you. Attorney Cogliano.
Good morning, Chief Justice and Associate Justices, and may it please the court. My name is Allison Cogliano, and I'm before you on behalf of the town of Barnstable. This case presents two related standing questions under 61A. Whether abutters and their nonprofit advocacy group have standing to seek declaratory or mandamus relief under 61A, and second, whether the court should extend the zoning law presumption of standing under 40A. And the answer to both questions is no, because Chapter 61A assigns the right at issue, the right of first refusal, exclusively to the municipality. And the legislature did not authorize private enforcement.
Is there any remedy at all for noncompliance with the notice statute?
Yes, Your Honor. The remedy, however, lies in the hands of the town. The non-compliance with the statute and the notice, and I'll take it back a little bit. If we're talking about case law, and we're talking about Sudbury v. Scott, and we're talking about the court's discussion on the legislative history and the legislative intent and strict compliance with the notice requirements, that is all to protect the town. The legislative intent, and I know, this is something that's going to continuously come up during my argument, is that the town has given a tax break in order to incentivize the maintenance of agricultural land, forest land, et cetera, farmland. In exchange, the case law is very clear and the statute is very clear that the town then receives this right of first refusal because it's sort of the last ditch effort, if you will, to get that agricultural land and maintain it if there's a wish to sell or convert. And so in order to do so, and case law does specify this, that the 120 days, the service requirements are all to have an ascertainable date where that 120.
Sorry, can we just back up still before we leave the notice? Mm-hmm. But the legislature didn't just require a notice to the town. The legislature required notice to the Conservation Commission, if there is one, and to the state forester. And it seems like it's pretty obvious that the legislature wanted to prompt a discussion among all of these people. So it's not just notice to the town, it's notice to all these different units of the town. Do you not agree that the town is in general obliged to reject a notice if it's not sent to all the people?
I don't believe that the town is obliged to reject it if at the end of the day the charter allows for the town manager to do so. The statute provides 30 days to reject that notice. It says the town shall reject it within that 30 days. I don't believe that's because there's an obligation to reject it. It's putting a time frame on this. It's saying if the notice is inadequate, you better remedy it within 30 days, or you sort of waive that opportunity to say, well, these parties weren't properly noticed, or the notice didn't include certain information that is required by statute. But at the end of the day, all of those things are to benefit the town, and to speak to Your Honor's point, those other parties that are to be served, I think that goes to there being a well-educated decision. And as my brother explained, the town council, Conservation Commission, and those other parties were eventually notified. And in fact, if we're moving to some of the facts of this case, the town attorney acknowledged that notice was defective. However, in all of that time, those parties were brought in, and those parties did have a discussion, and those parties went into executive session. And at the end of the
Sorry,
day,
are you going beyond the record here? Like, is it in the record that notice was given to the state forester, to the Conservation Commission? I thought that the only reference to the Conservation Commission was that at one point they said, hey, we want in if there's discussion.
Your Honor is correct. I don't believe it's in the record that the state forester was notified. And I think eventually the Conservation Commission was made aware, whether it was within 30 days, 120 days. But I would argue that that is an internal issue, leaving the state forester out of things. Otherwise, those are all town departments. And so if the Conservation Commission, similarly, and most commonly, the town council could actually bring suit against the town manager if they so chose. If they believe the town manager refused that or waived the right of first refusal as a mistake, or he didn't have the authority to do so. And I've seen that before, where city councils or town councils disagree with leadership's decision. And so,
But one of the things you made reference to was that this would be part of the procedural requirements, is that so people can make educated decisions about what to do. There's another component to their argument, is that there have been changes to not only the purchasers, but intended use, such that it's not just a distinction without a difference that folks didn't get this, that it may have made a big difference as to whether or not they were going to exercise whatever rights they had under the notice provision. How do you respond to that? Because it's related to my earlier questions about what are they to do if the town doesn't do what the statute requires them to do, and they have real consequences to people like the abutters.
I think that just brings us back to the question of standing. And at the end of the day, the legislature does not provide it to private parties or abutters. And so if there is an issue with notice
Is it a tough luck response you seem to be giving us? Is that what they get? Tough luck?
I hate to say it that way. Unfortunately, that is just the way that the legislature is drafted. And I think the case law is clear on the intent. I think, again, given the 30 days to reject the notice and the 120 days to waive the right of first refusal, it puts all the power in the town's hands. And
Might the plaintiffs have standing to pursue a different kind of claim? Because I'm thinking of a taking, for example, because they've got these easements going over their property, at least some of them, and the town's action here may somehow affect those easements, or is the town's view that those easements will not be affected? If the use of the property is changed, are all these easements limited to agricultural use? In other words, they can only pass over the plaintiff's lands for purposes of an agricultural use?
I would probably leave that question to my brother as the buyer of the property, or the representative for the buyer of the property. But I think in terms of perhaps zoning, if down the road something occurs on the land that abutters are not happy with, I understand that it's past this land's no longer agricultural use, and if it's going into residential, which I believe it will be, and although it is the residential zone, that's their opportunity to insert themselves and say, hey, we're abutters and we have rights to decide what does go on this property. But again, and I know I said I was going to continue to repeat myself, the 61A Section 14 was written as essentially a quid pro quo, tax break for agricultural land. And in the end, if it's not going to be agricultural anymore, it's the town, it's the municipality who provided that tax break, who gets that other end of the quid pro quo. And if they choose that if they decide they don't want to purchase the property, that is their discretion. And so in seeking declaratory relief or mandamus, firstly, mandamus, that's for ministerial duties. This is not a ministerial duty. And the plaintiffs have continuously argued in their brief and here today that the town somehow has this duty to reject the notice, this duty to purchase the property, when in reality, it's a right. And it's something that is waivable, and it's clear through the case law. And if we're speaking about the zone of interest, and if we're speaking about declaratory judgment, the plaintiffs rely on federal cases that are involving Article 3 injury. Those cases, plaintiffs in those cases had standing because they were the parties that the Article 3 was intended to regulate and protect. That is not the case here. If there are no more questions, because I have 17 seconds left, I would just say in the end, plaintiffs asked this court to recognize a private enforcement right the legislature did not create. Chapter 61A assigns the right of first refusal to the municipality and leaves its exercise to municipal discretion. Because plaintiffs are not within the statute's zone of interest, and because mandamus cannot compel discretionary decisions, the lower courts correctly dismissed the action. The judgment should be affirmed. Thank you.
Thank you. Oh, we've got one more person. Attorney McLaughlin.
Felt special there. May it please the court, I'm Matthew McLaughlin on behalf of the appellee Bog Partners LLC, and I'm joined by my colleague Aaron Natick. The Superior Court properly granted summary judgment to the appellees. The appellant's position in this case would elevate form over substance to a degree that would not only undermine a municipality's ability to exercise or not a right of first refusal under Chapter 61A, but it would also permit any abutter to invalidate or attempt to invalidate any such decision if there were any technical noncompliance with the notice provision, no matter how minor or inconsequential that technical noncompliance was. Abutters could sit and wait, like the appellants did here, for a year before bringing in action, trying to undo the actions of the town. So as one example, it is indisputed here that the notice was defective in the sense that it was not provided by certified mail to all of the boards specified. But under the argument presented and advanced by the appellants, if in another scenario, the seller sent the notice of intent to everybody specified in the statute by registered mail, not certified mail, by FedEx, left off one of the individuals, the appellant's position is, notwithstanding the fact that the relevant departments may have had actual notice, certainly constructive notice, may have considered fully the intention and made a decision in conjunction with the relevant town bodies, that decision can be challenged down the road because of any technical noncompliance.
But the state, sorry,
No, please go ahead.
state forester isn't a component of the town.
Correct, Your Honor.
So you can't really take the position of constructive or actual notice to the state forester, correct?
I think that's right, although the statute itself doesn't provide any authority or powers to any of those entities other than to receive notice. There is no further authority that the legislature provided to any of those entities. And I think that's in furtherance of the purpose, which is if the town wants to assess whether to exercise the option upon receipt of that notice, it should be able to do so, and it should have the relevant information in order to make that decision. So I don't think the fact that the state forester, who is a listed person, necessarily changes that result.
But here, your brother makes a slightly more nuanced argument for standing, and that is that nothing was done here. So, would the calculus about standing be different if the town officials did nothing?
It did nothing in the sense...
Did nothing with... so they couldn't do anything for those axiomatically that didn't get the notice, because you wouldn't know what to do if you didn't get notice to begin with. But it presupposes that they get this notice and, as your sister said, made an educated decision about what to do as a result. And if there's evidence that they did nothing with it, would that be enough to confer standing?
I don't think so, Your Honor. I think as the appeals court said in the Riley v. Hopedale case, and I think the appeals court got it exactly right there, the fact that residents of the town may have an interest in the property, may have aesthetic interest, may have an interest in open space, does not, that's an interest in the colloquial sense. That is not an interest sufficient to confer standing when you're talking about the Chapter 61 framework.
How about if you divorce that from an interest in their local town officials doing their job?
Well, I think that, again, if the legislature wanted to give expand the standing to interested parties like they did in Chapter 40, the legislature knows how to put that into the statute. They did not do that here. And as a result, it is the town and only the town. Had the town wanted to raise an issue at the early stages that the notice was defective and insist on a notice to be reissued, the town was in the position to do that. The town did not do that. And the fact that the initial notice from the town attorney identifying the defective notice was supplanted later on by the decision by the town manager, as evidenced in the affidavit submitted by the town manager, which occurred after the town council was clearly aware of it, after the Conservation Commission was clearly aware of it, I think is more than sufficient evidence to understand that the town's position was and remains that they do not want this property, and the court should not disturb the town's discretion to take that decision.
Okay, thank you.
Thank you.